Welcome to Chapter 2. This chapter is going to cover equal employment opportunity in the legal environment. Make sure you take detailed notes because this is a very weighted chapter dealing with a lot of public policy and different legal terminology and concepts that can be challenging. And of course, you'll be tested on it. So let's go ahead and jump into Chapter 2. By the end of this chapter, you should be able to define and describe equal employment opportunity, the intent of the Equal Pay Act of 63, Title VII of the Civil Rights Act of 64, define disparate treatment and disparate impact, the purpose of Age Discrimination and Employment Act of 1967, the purpose of the Rehabilitation Act of 73, the intent of the Vietnam-era Veterans Readjustment Assistance Act of 74, the purpose of the Pregnancy Discrimination Act of 78, the Immigration Reform and Control Act of 86, the Americans with Disabilities Act of 1990, the Older Workers Benefit Protection Act of 1990, the Civil Rights Act of 91, the Family and Medical Leave Act of 93, the purpose of Executive Orders 11246, 11375, and 11478, as well as Executive Orders and the intent of the Americans with Disabilities Act of 2008, the Lilly-Bednar Act of 2009, the significance of landmark Supreme Court decisions, and which some of those decisions include Griggs versus Duke Power, McDonnell Douglas versus Green. You have University of California Regents versus Bach, United Steelworkers of America versus Weber, just to name a few. You should be able to name the federal agencies that have primary responsibility for enforcing equal employment opportunity. So we talk about equal employment opportunity, but what exactly does that mean? It refers to the right of all people to work and to advance on the basis of their merit, their ability, and their potential. That's what it means to have equal employment opportunity. In 1963, we first started with an Equal Pay Act. And some of the employment opportunity laws and executive orders that have unfolded since, we still have enforced or have modified or made better sense of over the years. The Equal Pay Act, let me make sure I'm not getting ahead. Yes, I was. Okay, no, I'm good. The Equal Pay Act of 1963 prohibits sex-based discrimination in rates of pay for men and women that are working on same or similar jobs, and the act basically permits differences in wages if the payment is based on seniority, merit, quantity of production, quality of production, or if there's a differential due to any factor other than sex. So that means the act also prohibits an employer from attaining compliance with the act by reducing the wage rate of any employee. This is supposed to help keep women from being discriminated against in the workforce, in the workplace, to not receive lower wages if they're doing the same jobs or similar jobs. And making sure that if we're at the same seniority level and doing the same or similar work, we get paid the same. If our merits are similar or the same, we get paid the same. If we're doing the same quantity and quality of production, we get paid the same. That is what the Equal Pay Act is supposed to be, is how it's supposed to be enforced. 1964 became the Title VII Civil Rights Act. And it's a keystone federal legislation within equal employment opportunity. Section 703 of this act covers two basic areas of discrimination. We have this disparate treatment and disparate impact. Disparate treatment, it refers to intentional discrimination, and that involves if we treat one class of employees differently from another. Disparate impact refers to unintentional discrimination, and that happens when employment practices appear to be neutral, but you realize that they're adversely impacting a protected class of people. 1967, and we'll discuss protected class of people as well. That's anyone based on race, religion, age, physical limitations, and things of the sort. So there's a protected group of people. And I believe Chapter 1 covered that more. Age Discrimination in Employment Act of 67, which is ADEA, it prohibits discrimination in employment against anyone who's between the age of 40 through 69. And the prohibited employment practices of ADA includes failure to hire, discharge, deny employment, and discriminate with respect to terms or conditions of employment because the person's age falls within that protected age group of 40 through 69, which that impacts a lot of us, especially now that you have people having to change careers or change to another job because they've been laid off and now they're back in the workforce. You have people re-entering the workforce after taking time off. You also have baby boomers who are realizing they cannot retire and they're having to come back into the workforce or take on other jobs. And so this is where this act was in place in 67 in order to protect this group. The Rehabilitation Act of 73 has been amended to contain the following provisions: that it prohibits discrimination against quote-unquote handicapped individuals by employers with federal contracts and subcontracts in excess of $2,500. It requires that there is a written affirmative action plan from employers that have 50 or more employees with federal contracts of $50,000 or more. It prohibits discrimination against quote-unquote handicapped individuals by federal agencies. It requires affirmative action by federal agencies to provide employment opportunities for these quote-unquote handicapped persons. It requires federal buildings to be accessible to these individuals. It prohibits discrimination against them by recipients of federal financial assistance. There's a subsection in the Act that defines a handicapped individual as any person who has had a physical or mental impairment which substantially limits one or more of their major life activities. There's a record of such an impairment or is regarded as having such an impairment. And so this does not include a person who is an alcoholic or drug abuser whose current use of alcohol or drugs prevents them from performing their duties in question. So that's where that act first came in play and was approved by Congress in 73. The Vietnam-era Veterans Readjustment Act of 74 prohibits federal government contractors and any of their subcontractors that have federal government contracts of $10,000 or more from discriminating in hiring and promoting Vietnam and disabled veterans. It requires if an employer has 50 or more employees and contracts that exceed $50,000, they have to have a written affirmative action program with regard to the people protected by this act. The Pregnancy Discrimination Act of 78 was an amendment to the Civil Rights Act of 78. And the PDA, as it's called, states that women that are affected by pregnancy, childbirth, or related medical conditions shall be treated the same for all employment-related purposes, including receipt of benefits under fringe benefit programs, as other persons not so affected but similar in their ability or inability to work. What was happening in the past was that companies were finding a way to not provide pregnant women or women that were impacted by childbirth or pregnancy. They're blocking them from receiving various benefits that they were offering to other employees. And so this act was passed by Congress. The Immigration Reform and Control Act of 1986, with the increase of illegal immigrants to the U.S. who did not properly go through the protocol to become legal residents and citizens. When when they don't have certain skills or they don't speak English, what happens is employers are abusing them by not paying them properly, by mistreating them, not giving them adequate rest, not providing them with safe facilities, so on and so forth. So in 1986, this act was passed, making it illegal for anyone to hire, recruit, or refer for employment in the United States a person known to be unauthorized immigrant, or as they say in the text and elsewhere, quote unquote, alien. It was done supposedly to prevent abuse of this protected class of people. Because they were, if they were unskilled and didn't speak English, so on and so forth. Of course, this is one of the reforms and the acts that is, of course, being challenged in regard to. There can be some loopholes. There's a lot of people that argue certain elements of this as well. Now, with the Americans with Disabilities Act of 1990, it gives people with quote-unquote disabilities sharply increased access to services and jobs. So employers cannot discriminate in either hiring or firing a disabled person who's qualified for a job. They cannot inquire about whether or not the person has a disability, although you can ask about their ability to perform a job. An employer cannot limit advancement opportunities for a disabled employee. They cannot use tests or job requirements that tend to screen out disabled applicants. They can't participate in contractual arrangements that discriminate against disabled persons. The Older Workers Benefit Protection Act of 1990 provides for protection for employees over the age of 40 in regard to fringe benefits and gives employees time to consider an early retirement offer. Wow, I just never considered myself an older worker, but I'm sorry. Under this act, employers can also integrate disability and pension pay by paying the retiree a hire of two, where they can integrate health insurance and severance pay by deducting the former from the latter. And in certain cases, if there's a plant closing or if there's going to be any mass layoffs, you can then, as an employer, integrate your pension and severance pay by deducting that severance pay, the amount added to the pension. Under the Civil Rights Act of 91, this allows women, persons with disabilities, and persons who are religious minorities to have a jury trial and sue for punitive damages of up to $300,000 if they can prove that they are victims of intentional hiring or workplace discrimination. This law covers all employers that have 15 or more employees. A second aspect of this act is concerned with the burden of proof for companies where they have intentional discrimination lawsuits. And so the court began to ease the burden of proof requirements on companies around 1989. The Family and Medical Leave Act of 93 enabled qualified employees to take prolonged unpaid leave for family health-related reasons without fear of losing their jobs. Under the law, you can use this leave if you're seriously ill, you have an immediate family member who's ill, or in the event of birth, adoption, or placement of a foster child. Americans with Disabilities Act's amendment of 2008 expanded the definition of what constitutes a disability, and what it did was overturn the Supreme Court's decision of 1990 in a way that it made it difficult to prove that an impairment is a disability. So with this amended act, it made significant changes to the definition that broadens the scope of coverage and the rights of employees with physical or mental impairments. The Lilly Ledbetter Pay Act of 2009 states that there's a 180-day statute of limitations for filing an equal pay lawsuit regarding any kind of pay discrimination resets with any pay discrimination, and it resets with each new paycheck affected by that particular discriminatory action. But it does not deal with the date that the employee received their first discriminatory paycheck. So before this act was passed in 2009, the Supreme Court had said that the statute of limitations for presenting these lawsuits would begin on the date that the employer makes that initial wage decision, not at the date of the most recent paycheck. Now, we talked about Executive Orders 11246, 11375, 11478, and these were issued by the President of the United States to give direction to various governmental agencies. The first one, 11246, was issued in 1965, requiring non-exempt federal contractors and subcontractors to not discriminate against employees and applicants because of race, sex, color, religion, or national origin. It required contractors and subcontractors to agree to comply to various provisions of the executive order and rules and regulations that the Secretary of Labor had issued. And the Secretary of Labor would have access to look at the contractor or subcontractor's books and records for any investigations. And there was a clause included for equal employment that every subcontractor or purchase order had to have provisions that would bind them as well as the vendor. It required employers that have 50 or more employees and contract and subcontracts that exceeded that of $50,000 to have a written affirmative action plan. And then 11375 was amended the 11246, and it also prohibited sex-based wage discrimination for government contractors. Then in 1969, OPM issued the Executive Order 11478, which in part suspended 11246 along with revised regulations. And here is the slide, the slide showing you in detail the Equal Pay Act of 63 that I talked about. Just going to make sure the slide shows it. Of course, I always get ahead of myself, right? Because what would I be if I would not get ahead of myself as I thought I would do? So I'm going to catch up to myself now. And I'm almost there. Oh, and there's something about 11246 I don't think I mentioned, which was the utilization evaluation, where it had analyses of minority group representation in all of the different job categories that covered both past and present hiring practices. It included an analysis of all upgrades, promotions, and transfers, so they could see clearly across the board what the job entailed, and to make sure that no one was being discriminated in any of those ways. And I mentioned OPM, the Office of Personnel Management. So, go back up. There we go. So we have state and local government equal employment laws, and many of the local governments, state and local governments, passed equal employment laws, but there's a point where you have to note the supremacy clause of the Constitution that actually states that the laws of the U.S. that deal with matters within jurisdiction are supreme, and the judges in every state will be bound by those that jurisdiction. So anything in the Constitution or laws of any state to the contrary fall within that. And so there's no federal laws that prohibit states from passing laws against discrimination in areas not covered by the federal law, as long as the law does not require or permit an act that is unlawful under federal legislation. So a state can go above and beyond what the federal laws already say. They can go further to make sure that there's no discrimination, but what they cannot do is come up with a new law that actually breaks the federal law. You can't then go back and try to change the laws and to actually discriminate against a class of people. So some landmark court cases, as I mentioned earlier, we had Griggs versus Duke Power Company, and this case was concerned about the promotion and transfer policies of the company at its Dan Rivers steam station, and Duke had permitted incumbent employees who had already lacked a high school education to transfer from an outside job to an inside job by passing 2 tests. However, there were African American employees who argued that these practices violated Title VII, since neither having a high school education nor passing the test was necessary for successful performance on the jobs in question. So in 1971, the court ruled in favor of the African American employees, and the decision established several significant points concerning equal employment opportunity. Let me back up. I'm making sure. Okay, I'm not getting ahead of myself. So the consequence was that it's not simply the intent or motivation of the employer that's part of this. It's looking at if there's any patterns of or continued past practices of discrimination, that all of those are considered illegal, regardless of the non-discriminatory intent of the employer. And the disparate impact doctrine provided that when a plaintiff, the person who is suing, shows that an employment practice disproportionately excludes groups protected by Title VII, that the burden of proof shifts to the defendant who is being sued to prove that the standard reasonably relates to job performance. So that the standard that you're setting in order to get the job actually has something to do with how you perform the job itself. And so the EEOC's guidelines that permitted the use of only job-related test skills as deemed appropriate. So if there was a test, it had to deal specifically with the job at hand. It couldn't have anything to do with something that you just pulled out of the air to say this is what the test is going to be. It had to do specifically with the job. So you had to perform the task of the job in order to prove that you could do the job well. With the McDonnell Douglas versus Green, Percy Green, an African-American man who'd been employed by McDonnell Douglas, was laid off because there was a reduction in their workforce. After the layoff, Green participated in a protest against alleged racial discrimination by McDonnell Douglas in its employment practices. It included a stall-in where Green and others stopped their cars along the roads that led to the plant and blocked access during the morning rush hour. Later on, McDonnell advertised for mechanics. Well, when he applied for reemployment, he was rejected by the company on the grounds of his participation in the stall-in, which the company argued was an unlawful conduct on Green's part. On technical grounds, the Supreme Court remanded the case back to the district court, but at the same time, its ruling set forth standards for the burden of proof in discrimination cases. So here's where the standards took place. The complainant, who was Green, the Title VII case carries the initial burden of proof in establishing a prima facie case. That means at first sight or before closer inspection. And that's how you establish the prima facie case of discrimination. If the complainant establishes that case, the burden shifts to the employer to provide some legitimate, non-discriminatory reason for rejecting that employee. The burden then shifts to the employee to prove that the employer's allegedly legitimate reason was actually pretextual. So there's a lot of shifting back and forth, right? It's a lot of dancing going on. Basically, once you prove your side, the other person has to prove their side. And then you basically do the work to break it down for the Supreme Court for them to then finally make a decision as to whether or not the company has a right to say you broke, your acts were unlawful or not, and whether or not you just discriminated against me because I was standing up to you and your discriminatory practices. With the hourly paper versus Moody, the company required applicants for hire into various skill lines of progression to take a beta exam and the Wonderlic test. Well, the company made no attempt to determine the job relatedness of the test, and they just simply adopted this national norm score as a cutoff for new job applicants. Well, they allowed African American workers to transfer to the skill lines if they could pass these two tests, but very few succeeded. So incumbents in the skilled lines, some of whom had been hired before the adoption of the test, were not required to pass them to retain their jobs or their promotion rights. So they didn't have to go through the process. 4 months before the case went to trial, the company engaged an expert in industrial psychology to validate the relatedness of its testing program. It showed that the tests were job-related. However, in June 1975, the Supreme Court found that the validation study was materially defective. The court's decision was based on the fact that the company's study failed to comply with EEOC guidelines for validating employment tests. And the court held that if an employer establishes that a test is job-related, it's the plaintiff's burden, the person being sued, to demonstrate the existence of other tests that could comparably serve the employer's legitimate interest with a lesser impact on a protected group. So that's what happened with that case. What is interesting about that is that there's a lot of companies that provide tests now, and so this is the burden that's always placed upon the companies to make sure that if you're going to have a test, that it falls in line with EEOC guidelines, so that you're also making sure that that there is an equal playing field across the board, and you're considering your protected groups. With University of California Regents versus Bach, this was the medical school at UC Davis that had opened in '68 with an entering class of 50 students. They had no African Americans, Hispanics, or Native Americans in the class. Alan Bach was a white male. He was denied admission to the school in '73 and '74. They said that minority students with lower grade averages and test scores were admitted under the special program. He then sued the school, alleging that the school had a special two-track admission system that violated the Civil Rights Act of '64. So he raised the issue of reverse discrimination that alleged that there was preferential treatment of one group, which was minorities and females, over another group rather than equal opportunity. June 28, '78, the Supreme Court ruled in a 5-4 decision that Alan Bach should be admitted to the medical school at UC Davis and found that the school's two-track admission system was illegal. However, by another 5-4 vote, the court held that at least some forms of race-conscious admissions procedures are actually constitutional. And I believe that, and this happens to do with the fact that there have been more cases of people not being admitted because of race and gender, right? Than people being admitted because of. And so being race conscious, being gender conscious is not unconstitutional. It is actually constitutional. It is not having a quota, is just being astute and alert that, wow, we have no people of color, and wow, barely any females. So we need to do a better job of looking closely at our candidates, recruiting candidates in these areas, and being mindful of that. We have United Steelworkers of America versus Weber in 74. Kaiser Aluminum and Chemical Corp and the U.S. Steelworkers of America signed a collective bargaining agreement that had a affirmative action plan that was designed to reduce racial imbalances in Kaiser's then almost exclusively white workforce. The plan reserved 50% of openings in the training programs for African Americans. At their Gramercy, Louisiana plant, Bryant Weber, a white male, filed a class action suit against the company because African American employees were accepted in the company's in-plant craft training program before white employees with more seniority. In the 1979 court decision, the Supreme Court ruled that the voluntarily agreed-on plan between Kaiser and the steelworkers was permissible. The court stated that the Title VII prohibition against racial discrimination did not condemn all private, voluntary, race-conscious affirmative action programs. So basically, it was saying that this program, that what they created, the plan that they created, was designed to break down old patterns of segregation. It did not involve discharge of innocent third parties. So it was not as though there was some kind of reverse discrimination going on. They were being mindful of the hundreds of years that they discriminated against African Americans. We then have the court case of Connecticut versus Teal. A Connecticut agency promoted several African American employees to supervisory positions contingent on their passing a written exam. When they failed the exam, the agency refused to consider them as permanent candidates for the position. The employees then alleged that Connecticut violated Title VII by requiring an absolute condition for consideration for promotion that applicants pass a written test, and that this test disproportionately excluded African Americans and was not job related. Well, the district court ruled that the bottom line percentages, which were more favorable to African Americans than whites, actually precluded a Title VII violation. The bottom line concept is based on the view that the government should generally not concern itself with individual components of the selection process if the overall effect of that process is non-discriminatory. So it did not provide the employer with a defense. In the Memphis firefighters, Local 1784 versus Stotts, this was about a conflict between a seniority system and certain affirmative action measures taken by the city of Memphis. In 1980, the fire department entered a consent decree under which the department would attempt to ensure at least 20% of their promotions in each job classification would be granted to African Americans. It was silent on the issues of layoffs, demotions, or seniority. So it didn't cover those areas. Well, in May 81, the budget deficits caused some layoffs of personnel, and it was based on seniority. The district court issued an injunction ordering the city to refrain from applying the seniority system because it would decrease the percentage of African American employees in certain jobs. The city then used a modified plan to protect the African American employees, and the Local 1784 firefighters filed a lawsuit objecting to this modified plan. In 84, the Supreme Court ruled that the district court had exceeded its powers in issuing the injunction, requiring white employees to be laid off when the normal seniority system would have required laying off African American employees with less seniority. This decision did not ban the use of affirmative action programs, but it does indicate that a seniority system may limit the use of certain affirmative action measures. So what it was saying is you cannot lay off white employees who have greater seniority to hold on to and protect African Americans and other minorities who have junior seniority, have less seniority, just because you're trying to maintain a 20% kind of quota in a sense. You can't do that. So if it goes based on a seniority, you have to lay off based on that. The City of Richmond versus J.A. Croson Company. This was a case in 1983 where Richmond City Council adopted an ordinance where a minority business utilization set-aside plan. And this required non-minority owned prime contractors that were awarded city construction contracts that they had to subcontract at least 30% of the dollar amount of the contract to one or more minority business enterprises. This is done to prevent non-minority contractors from only giving subcontracts to other non-minorities. And it happens, it's been happening. And so by establishing some of these ordinances and laws and things of that nature, it prevents the discrimination of minority business enterprises. Well, after the adoption of the ordinance, the city issued an invitation to bid on a project for provision and installation of plumbing fixtures at the city jail. The only bidder was J.A. Croson Company, who submitted a proposal that did not include minority subcontracting sufficient enough to satisfy the ordinance. The company asked for a waiver of the set-aside requirement, but the request was denied, and the company was informed that the project was to be rebid. The company then turned around and filed suit against the City of Richmond, claiming that the ordinance was unconstitutional under the Equal Protection Clause of the 14th Amendment to the U.S. Constitution. Well, in January 1989, the Supreme Court ruled that the City of Richmond's plan was unconstitutional. The court stated that the state and local governments must avoid racial quotas and must take affirmative action steps only to correct well-documented examples of past discrimination. The court went on to say that the 14th Amendment to the U.S. Constitution, which guarantees equal protection under the laws, requires that government affirmative action programs that put whites at a disadvantage should be viewed with the same legal skepticism that has been applied to many state and local laws that discriminate against minorities. So you can't turn around if there's only one person that bid, and that one person's white. You can't say, well, you have to have you have to show on your proposal that you're going to give 30%, blah, 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 and you're going to force, it wasn't sufficient enough to satisfy the ordinance, and at that we're going to rebid. But why? No one else was bidding on the project. Nobody else bid, just one company. And so you can't put the white contractor at a disadvantage based on you're trying to meet a quota. Can't do it. Another case that we have is Wards Co. versus Antonio. This was June 89. Supreme Court, in a closed decision 5-4, made it easier for employers to rebut claims of racial bias based on statistical evidence. This case developed from discrimination charges against Wards Cove Packaging Company of Seattle and Castle and Cook Inc. of Astoria, Oregon. The companies operate salmon canneries in remote areas of Alaska during the summer salmon run. And minorities alleged that while they held nearly half of the jobs at the canneries, the jobs were racially stratified, with whites dominating the higher paying jobs, such as machinists and carpenters and administrators. The company argued that statistics showing that minorities held most of the lower paying seasonal jobs and fewer better positions did not prove discrimination by the company. The Supreme Court comes in. They decide that when minorities allege that statistics show they are victims of discrimination, employers only have the burden of producing evidence that there is a legitimate reason for its business practices. It ruled that an absence of minorities in skilled jobs is not evidence of discrimination if the absence reflects a dearth of qualified minority applicants for reasons that are not the employer's fault. So the Civil Rights Act of 1991, in effect, reversed this Supreme Court decision. So it's like just a few years later, the Civil Rights Act reversed this. Martin v. Wilkes. You have a group of white firefighters that sued the city of Birmingham, Alabama, and Jefferson County Personnel Board, alleging they are being denied promotions in favor of less qualified African-American firefighters. Prior to filing the suit, the city had entered into 2 consent decrees that included goals for hiring and promoting African-American firefighters. In filing the suit, the white firefighters claimed the city was making promotion decisions on the basis of race and reliance on the consent decrees, and that these decisions constituted racial discrimination in violation of the Constitution and federal statutes. The district court came in, they reviewed everything, and they held that the white firefighters were precluded from challenging employment decisions taken pursuant to the decrees. However, June 12, 1989, the Supreme Court ruled the white firefighters could actually challenge the promotion decisions made pursuant to the consent decrees, and the court ruled that the white firefighters could bring reverse discrimination claims against court-approved affirmative action plans. So while in the local and state and city and even employers trying to make sure that we don't discriminate against protected groups, we need to also make sure that we're not also discriminating against whites, right? You have to make sure that you're not discriminating against non-minorities. And what you're seeing that it's, over the years, it's happened, and that's the reason why you hear more and more people saying it, because they're feeling it or they think that they're experiencing it. And if you have these landmark cases that kind of pave the way, it makes you feel as though it's more happening more frequently than maybe it is. And then again, it could very well be. We have Adirondack Constructors versus Pena. The Adirondack is a guardrail contracting firm. They sued the U.S. government for allegedly applying race-based standards in granting public works contracts in Colorado. The suit stemmed from a subcontract from guardrail work that Adirondack had lost in 1990, despite submitting the lowest bid. So they came in with the lowest bid and they were denied the contract. The subcontract was given to Gonzalez Construction, a minority-owned business, by the main contractor because the Central Federal Lands Highway Division gave cash bonuses to prime contractors that hired minority-owned businesses. Prime contractors are the bigger contractors who get most of the bids. They're the big wigs. And so by getting a cash bonus, by hiring a minority-owned business, you're more inclined to, guess what? Hire out a subcontractor that's a minority-owned business. So in a 5-4 decision, the Supreme Court questioned the constitutionality of government measures designed to help minorities obtain contracts, jobs, or education. The decision did not scrap outright the federal programs that decades had been built to give minority-owned businesses a competitive edge over majority-owned businesses. But it did require that the lower courts had to apply strict scrutiny to those programs to make sure that there's no reverse discrimination, things of that nature. With the state of Texas versus Hopwood, that's March 1996, the U.S. District Court of Appeals, Fifth Circuit, rendered a decision that was dealing with the affirmative action program at the School of Law, University of Texas. The affirmative action program gave preferences to African Americans and Mexican Americans in the admission program to the School of Law. The program was initiated in response to a history of discrimination against both of these groups in the state of Texas. It was clear they were being discriminated against. The district court concluded the law school may not use race as a factor in law school admissions. Well, on June 25th, 2001, the Supreme Court turned down an appeal by the School of Law of the University of Texas. So, they could not use race as a determination of admission. University of Michigan's admission procedures of 2003, Supreme Court issued 2 decisions dealing with affirmative action measures. at the university that they used its undergraduate and law school programs. Both cases were brought by white applicants who had been rejected for admissions to the university. In the law school case, that was Grota versus Bollinger. The court approved the use of a holistic approach that considered race as one tool in the admission process to achieve a diverse student body. However, in the undergraduate program case, Gratz versus Bollinger, the court rejected the point-based process. They gave an automatic boost to African Americans, Hispanics, or Native Americans. The court said the schools cannot maintain quotas or separate admission tracks for racial groups, and that diversity cannot be defined solely on the basis of race. These two decisions are viewed as a victory for affirmative action. And the reason why is, although there's been a long history of discrimination against racial groups, you're then doing the exact same thing in reverse. And so you can't. It has to be equal opportunity, right? You can sit back and say, let's make sure that we make a concerted effort to promote more, to be mindful of, but you cannot have a two-track system. You can't have a system for white applicants and then have this other system for minority applicants based solely on race, and then you deny white applicants and you're not doing, and it's only based on race. It's not based on the fact that, test scores and other achievements and all these other kind of, things. It's just based on the race. And that in itself is doing exactly what was happening to racial minorities for years before. So we look at EEOC and our enforcement agencies. And we have two federal agencies that have the primary responsibility for enforcing equal employment opportunity legislation. EEOC was created by the Civil Rights Act to administer the Title VII of the Act. Originally, it was responsible for investigation of discrimination based on race, color, religion, sex, national origin. Now it's also responsible for investigating equal pay violations, age discrimination, and discrimination against disabled persons. Amazingly enough, there are some states that have very high rates of age discrimination where applicants are being discriminated against because they are older. And companies are like, oh, we don't want to have to pay out the medical cost and so on and so forth to these older candidates. So, and I believe that, and I could be wrong, but I believe the state of Oklahoma is like ranked number 2 in the nation for age discrimination. Random fact that was shared with me. So, the EEOC also has ability and authority to investigate charges and complaints in these areas, but they can also intervene through general counsel in a civil action on behalf of an aggrieved party. Their powers were expanded in 1979, as I said, and they're composed of 5 members. More than 3 cannot be of the same political party to make sure that there's no undue influence. So within the office of, you have the Office of Federal Contract Compliance Programs, and they're within Department of Labor. Unlike the EEOC, which is independent agency within the federal government, this particular office is within the U.S. Department of Labor. So it was established as part of Executive Order 11246 to ensure that federal contractors and subcontractors follow non-discriminatory employment practices. So, you have one that's outside, external, and one that's inside. Let's make sure that when you go back through, there's a lot of content that I've shared. Of course, you have the actual PowerPoint slide in your course room. You have to go through and just find some key words within each so that it's easier for you to retain the information and have a better recall of it when you need it for exams of the sort. If you have any questions, you know how to reach me. Please send me an email and I will follow up with you as soon as possible. Thank you for everything, and I hope that this video has been helpful and explained in greater detail some of the content that you're reading in the textbook.